Thanks to you everyone for joining me here today. We are going to do a webinar on EEO related subject matter. A little bit about me. I am a partner here with the law firm. I've been doing exclusively employment law now for 15 or so years, focusing mainly in the federal sector sphere. You see a little bit about my bio there in the background, but certainly EEO is a big aspect of our practice here at Tully Rinckey. I'm going to discuss a little bit about the informal phase, as was noted on that first slide. So the scope of our webinar here will be somewhat limited, but hopefully it will be helpful for those in the federal space to keep an eye out for issues if there is in fact employment disputes in the workplace, and what to keep in mind in the event that you're questioning whether the conduct in the workplace is in fact lawful. So with that, we can jump into our material. So again, a little bit about what we're going to go over here today. The laws that protect you from discrimination in the workforce. Really starts with the granddaddy of them all, right? The 1964 Civil Rights Act, Title VII, and derivative civil rights statutes that afford us protections both in the private sector as well as the public space, the federal sector. What I'm going to be focusing on here is administrative remedies through, again, the federal workplace, namely the executive branch, which is set forth in regulations. So it's going to be a little bit different from our private sector brethren, but that being said, it is important to have sort of a general understanding of how these cases are processed from a federal perspective. What is an informal complaint? It's really it initiates this process. It starts a complainant's requiring to exhaust his or her administrative remedy. So that's really what an EEO complaint is. And what are we meaning by EEO complaint? Equal employment opportunity, right? So some of the things you're going to be looking for in the federal space is, why am I being treated unfairly? If in fact that is your issue, and you're going to want to look to equal employment opportunity issues, right? What is that? It's the basis of why there could potentially be disparate treatment in the workplace, right? Race, sex, national origin, religious discrimination, age, prior EEO activity, disability. These are all aspects of an EEO complaint that are judiciable through this process. So that's something you're going to want to look at. It's always the basis of your complaint. As we go forward, EEO is not a general civility forum, right? I mean, you can't just go to this forum and expect relief on just any kind of basis. So it's important when you're thinking about these cases to sort of identify the causation behind what we're talking about here. So then we get into how to file an informal complaint. We're going to be talking about that. How to initiate contact with the counselor. That's part of our discussion, as well as that first phase in this administrative process, which is the informal phase, and that comprises of either mediation or traditional counseling as you're sort of launching your EEO complaint. So we can move forward. So as I mentioned, hugely important here, right? Title VII, 1964 Civil Rights Act. Bases, some are enumerated here. Important to know that various jurisdictions have expanded these provisions. So just because it might not be listed here, it's always good to run it by someone, a lawyer that has the knowledge about a specific jurisdiction, because there can be, causes of action in state law. But for what we're talking about here, we're talking about the federal level. We're talking about Title VII, and we're talking about disparate treatment / discrimination. Race, sex, national origin, color, religious discrimination, age. You can see that for the subset of persons 40 and older in the workplace, and also disability, which includes perceived disability or individuals with a record of disability. So we can move forward as well. Smaller sort of cause of action here. Genetic Information Discrimination Act of 2008. We're not going to really discuss that too much other than that point that's there. Pretty specific cause of action, but it certainly is a cause of action that applies to federal sector employees. Retaliation, common theory, that we need to always keep an eye out for, right? So here it's a sort of a good slide to broach on that. It's illegal or unlawful to retaliate against someone because they engage in protective activity. What is that? Really two umbrella types of activity, right? We have opposition activity and we have participation activity. So opposition, opposing explicitly or implicitly a practice made lawful under the above anti-discrimination statutes. In other words, you're opposing some sort of activity in the workplace that you perceive as unlawful based on EEO grounds, right? So whether that's sticking up for a coworker and opposing some sort of sexual harassment in the workplace, that could be considered opposition activity. The second umbrella there, participation in activity, right? You go to an EEO hearing, you try your case against the managers that have been treating you, presumably unlawfully, and then the next day, the next week, bad things happen to you, you're fired, you're given a proposed removal, whatever the case may be, that could potentially be unlawful activity as far as reprisal is concerned. It's important to think about in this space, we often as lawyers hear reprisal being, noted by our clients, and I understand that there is a lot of confusion there. There could be reprisal for various things, right? You could be reprised for whistleblowing activity. That would be presented in another forum, which isn't related to this discussion. So it's always important in these cases, to identify causation. What is the causation here? It's opposition or participation concerning EEO activity, right? That's really the underlying prompt that you're going to want to take a look at when you're dealing with these cases. So, all right, next. Discrimination based on race. I'm not going to read the slide here. Basically, disparate treatment based on the immutable characteristics such as race or color, right? It's unlawful as far as Congress identified through the 1964 Civil Rights Act. Doesn't have to necessarily be someone of a different race that's treating you disparately because of race. So there's that point there. Race and color sort of a corollary, a little bit more of a narrow subset. It's based on the complexion of the skin rather than necessarily a racial classification. Next. Sex is part of the bases that are enumerated under the 1964 Civil Rights Act, right? And there's sort of different theories here that can be part of an EEO complaint, right? An informal EEO complaint. Discrimination just based on gender identity could potentially be part of it, as now codified through EEOC case law in recent years. Sexual orientation. Sex is generally man versus woman, either one, right? Being treated differently based on sex. Of course, there is a sexual harassment component, which can be just based on, again, man versus woman, or it can be of sexual nature, which is also unlawful, sort of really where the crux of this body of law began, sexual harassment. You're looking at that case like any harassment case. I think there may be other slides on this, but the severity and the pervasiveness of that conduct, whether it's sexual in nature, whether it's unwelcomed, right? So there are different legal prongs around all these actions. I'm not going to dive in really to the depths of the legal aspects of these things, but that's something that certainly is something to keep in mind if you feel like you're being harassed at work, right? What's the severity? What's going on? Are they comments to me? Is it physical touching? What's the nature of the action? Does it go directly towards sort of a quid pro quo sexual issue? Does it just involve favorable treatment versus men are treated more favorably than women, or vice versa? So identifying those things is really the primer to begin, thinking about these cases. The law doesn't prohibit simple teasing, offhand comments, or isolated incidents. That's true. So again, that goes to that sort of balancing test, if you will, with pervasive and the seriousness of the conduct. Doesn't need to be, harassment is not necessarily just sex-based. It can be based on race. It can be based on disability. It can be based on age. It can be based on any of the categories that are protected under EEO law. So This is really a theory, but the bases can hold true, regardless of classification under Title VII. Next. Discrimination based on disability. Okay, so here's some definitions here. Again, not going to get too far into this, but broadly, the law is very broad, right? If there is a medical condition that is ongoing and it's not temporary in nature, there's a good chance that it's protected by law. So that's something to keep an eye out in the workplace. And we see, obviously, disability discrimination, for better or worse, is an area where agencies frequently trip up. Next. So reasonable accommodation right here. Okay, a lot, there's a lot to these analyses, but basically whether an individual can perform the essential functions of the position held or desired with or without reasonable accommodation, right? So if you have a medical condition, that is legally defined and contemplated by law, and you need a reasonable accommodation to perform an essential function of your position, in so many words, the agency is obligated to do that. But for potentially this undue hardship reference above. So, it's definitely an area that we see frequently. It's something that you're going to want to talk to a lawyer about. There are a lot of wrinkles in this body of law. But, that being said, there is, this is something you want to think about when you're framing, again, your informal EEO complaint. Okay, we can move on. Religion, two separate protections here. Yes, it is unlawful to discriminate based on one's religion. Prohibit discrimination, right, based on religion is the first prong there. And then there's a sincerely held belief aspect of this body too. We don't see a whole lot of these cases, but they do pop up, certainly sort of in the public health sphere. Have seen some in the vaccination issues, so that it's an area that you're going to want to, think about too when you're framing that complaint. If you're in fact you believe that the causation is based on your religion, then by all means you are protected under the law. Okay, next. All right. So sort of getting into the processes now, but with filing an EEO complaint. Know the bases for discrimination claims. Absolutely. So this is really something you're going to want to think about before you launch into that. There's a reason reprisal laws exist, right? Employers don't necessarily love it when you file an EEO complaint against them. You're launching a Title VII, or you're essentially alleging that they violated federal law. It's unlawful, and you have every opportunity to prove it. Sometimes, latent motives are difficult to prove, in any of these cases. So it's going to be something you're not going to want to take lightly, and you want to think about the bases before you just jump into a complaint. Sometimes we see pro se or individuals without, representation that check all the boxes, right? Well, that's not really a good pleading practice, right? Because I never have seen a case where an individual is able to prove every basis. So, really you're detracting from the crux of your case by doing that. So upfront, knowing the bases is really important. It's very important. All right, there's a difference between discrimination and universal jerk in the office. Yeah, absolutely, right? I mean, there's no equitable issue here in the EEO world. You need to show underlying causation at the end of the day. So if there's a manager that's just difficult to get along with, or is having, issues across the medium, whether that's whites, blacks, men, women, is just a difficult supervisor, you're not going to win that case, right? Because it doesn't violate EEO laws. So that is true, but of course there is sort of Me Too evidence, right? This person of my same race was treated poorly by this manager, so that could potentially corroborate my theory. Okay, that's something different, right? So the idea of disparate treatment, it really revolves around that in the EEO sector. Yeah, I think we touched on that last point. So we're ready to move on. All right. Filing an informal EEO complaint. So now you're sort of getting into pitfalls, right? And I mean, The regulations are rife with pitfalls, right? That's why a lot of cases are unsalvageable by the time they come to lawyers, because these initial phases are immensely important to comply with, later litigation. You as the complainant have the burden of exhausting your administrative remedies. So if you fail to do that, an agency will be successful in dismissing that claim. So contacting the EEO counselor, that's the first part. That's per regulation. You have that obligation to do that in a timely fashion. You see that the next day. 45 days is the general rule. There are exceptions to any of these rules, right? But the general sort of guidance is something bad happens to you at work, 45 days, you better be able to prove your EEO contact with the counselor. Best to do that in writing. The agency, by regulation, is required to provide you notice as to who the proper counselor is. So that's, something that should be in the office. Certainly your manager should be able to point you to, even if it is a responsible manager, point you to the correct counselor. So the EEO counselor, that's the point of contact. It's not the EOC. It's not the, it's not the agency investigator. It's not an IG. It's not, it's not the HR contact. It is an EEO counselor. Now, again, you may be successful to saving a claim if you go to one of those individuals, but it's not correct practice, and it leaves your case susceptible for being dismissed. So contact the counselor. Remember your deadline, 45 days. Missing deadlines mean end of story. Fortunately, it's true. I mean, it's difficult to resurrect these things, at least resurrect these things where there's possible damages associated with these cases. So 45 days is an important deadline. Frame your complaint. Describe the discriminatory act in detail. I would say in proper detail. I'm not really a fan of that language there particularly. Proper detail, in my opinion, and we see this quite a bit, is basically what tracks federal court pleadings, right? Long story short, notice pleadings. Just the basics, timeline, the responsible manager, the issue involved. It's a chronology is what it is, and it links up to the bases that we talk about. So this is another reason why it's important for a lawyer to properly frame these claims. I can't tell you how many clients, submissions that I have read over the years where, you're into like three or four pages of single spaced paragraph, densely formatted narrative, and there's no claim there. And as we'll talk about, there's no responsibility of an EEO counselor to frame your claim for you. That's on you. So proper notice pleading is immensely important to lay those things out, to show to the reader that the complaint was timely filed. Understanding the bases. Yep, it's all about that. EEO. Okay, next. All right. So you filed your EEO complaint, preferably. Certainly our practice is to do that in writing. There are situations where there are phone interviews as far as initiation. Obviously, as you can imagine, the record is more difficult to track when that happens, but it is something that does happen. But in any event, you now have filed your complaint one way or another. Now you're meeting with the counselor. So, sort of the umbrella here, an EEO office, by regulation is a neutral entity. So it doesn't work for the agency. They're getting paid by the agency. Take that as you like, but it's supposed to be by regulation a neutral entity. So they're going to give you, present you with options. They're not there to advise you. But they're going to ask for, your choices as far as how to proceed in that informal complaint phase. Again, we're in the informal phase. So, there's a lot going on here, but, basically there's two options you have. You have a traditional counseling period, and that's where you see that 30-day period, unless the complainant agrees to extend. In that circumstance, if you go that route, the counselor is going to act as basically a go-between you and the agency, right? They're going to get some informal testimony. Testimony strong. It's not under any kind of penalty of perjury. Sort of the account of the manager. They're going to get their story. They're going to get your story. And that's basically it. That can be strategically advantageous because it is only 30 days if you want to, get moving on your case, because as you will see that these cases are long, but there's not a lot to the traditional counseling period. Alternatively, you can elect the ADR program. There's a neutral mediator that may or may not be, an agency employee. It could be an outside mediator that comes to try to mediate the employment dispute that's, that has been alleged to violate EEO laws. If you go this route, even more reason to hire a lawyer. You're negotiating. A lawyer can give you a sense on what's at issue in your case, what the proper remedy is in your case. In light of the length of time that it was going to take to try a case. So, these are real assessments that happen up front in that first 90 days that, is really imperative to understand where this case is going to go. And then it starts to move into where we're not going to really spend a lot of focus today, and that's the formal complaint phase. If after that 30 days, either in traditional counseling, the counselor is unable to resolve the case, or through mediation, the mediator is unable to resolve the case vis-a-vis the parties, then you have the option to continue this process. And you do that through the formal complaint phase. You'll see a note there at the bottom of the slide how to do that. Within 15 days of receiving the notice of right to file, the complainant has the election to file a formal complaint. Again, a regulatory deadline, unforgiving. You file day 16, you have no case. So that's sort of how that all plays out. But really, the informal phase is designed to be informal. It's not a fact-finding endeavor. Not necessarily. It's more oriented towards to seek early resolution, to kind of resolve these things at the least common denominator, which is really at the dispute phase. So that's what you're looking at when you're working with the counselor there. All right, we can move forward. Okay, mediation, right? So you have some information that's really helpful about that. Obviously, both parties have to agree. If the agency doesn't want to agree, and a complainant's demands are unreasonable, or maybe the agency's acting unreasonable as far as resolving a case, there's no requirement that either party go to mediation. Now, from experience, generally, if the complainant elects mediation, the agency will try to mediate the case. What else? 90 days, that's sort of the time frame from when you first speak to that counselor to the time the mediation wraps up. That's a timeline that these counselors are tracking, right? So, as part of my practice, I'm always after these counselors to, push things through to try to get to that mediation phase. So, you do in fact get your day to mediate within that 90 days. On day 90, if there hasn't been a mediation, you're going to go formal, and that is what it is. You can still mediate during that time frame, but really, again, the design of the informal phase is to try to resolve these things. All right, I think I hit on everything there. So yeah, we do all of this stuff. Anything that you may have a question about, from drafting to filing to meeting with counselors to mediation, to just giving you advice. I mean, we can assist you with anything EEO related in the federal sector. Right. Yeah, I mean, this next slide deals with a little bit about the consultation. So, this would obviously predate. Generally, what happens is there's a consultation, retain the services of a representative, and then the representative then initiates the complaint on behalf of the complainant. Thereafter, all the communication vis-a-vis the agency and the complainant is done through counsel, which of course is nice because your lawyer is controlling the record rather than you sending something inadvertently, and it harms the case. I mean, I've seen that many times, right? EEO is the game in town, and before the lawyer gets there, the client, although there is underlying evidence of discrimination, whether that's direct or circumstantial evidence, sends an email inadvertently, and it can be construed as a personality conflict rather than an EEO case. Well, guess what you're going to see? A motion to dismiss citing that email that the client provided. And it's difficult, it's difficult no matter, what kind of evidence is facing you. I mean, the judge is going to, grapple towards that. Even the complainant doesn't, feels like there's not an EEO basis here. So anyway, filing the initial complaint What you want to do there, sort of this notice pleading that I was talking about, what took place? When did it take place? Over what period of time did it take place? Is it continuing in nature? Who initiated these acts of unlawful activity in the workplace, right? Were there witnesses to the acts? So these are hugely important when you're framing the complaint. And again, when we're doing this, we have an eye towards that 45 days, towards timeliness issues, towards judiciability issues, right? We see things where, a lot of times clients are trying to, bring in another process as far as a discriminating one, right? I filed a workers' comp claim and they ruled against me. Well, that's not judiciable under the EEO law. There's regulations on that. And that's something a lawyer needs to tell you, right? What can be presented in the forum? What has jurisdiction over the forum, right? Hugely important. So, there's a myriad of different things that EEO just won't hear by nature of that. I think there's a slide a bit later. Mixed case, right? Hugely complicated area of this process. But you go to an EEO counselor and you say, I was fired based on my race, and I'm a tenured, essentially tenured, career conditional or career appointed federal employee. The EEO will hear that and process that claim, but ultimately that case is going before the MSPB, which may or may not be the way to go, right? So the framing early on, again, is hugely important. Contact information, the counselor, yeah, that's something that certainly we rely on. We're not agency employees. We don't have access to the role. Sometimes, that's online. Oftentimes it's through agencies' intranet. Sometimes it's in the cafeteria or the coffee, around the coffee cooler, whatever, water cooler. So, there's these things that are posted, but, that's something that is one of my first questions I ask a newly retained EEO complainant is, who's your designated counselor? All right, next. Yeah, we talked about all these points. Maybe the last one there. No, it's not so long if you're able to settle your case there at the 90-day period, right? So, that's the designation of the informal phase, what really brings us together today to talk about. So, could be a long battle if the case doesn't settle, and the clients need to be aware of that. Could be years and very resource intensive to battle an agency, that essentially have a general counsel paid on taxpayer dollars, right? It's a difficult road to hoe. There's no question about it. But that informal complaint phase represents an amazing opportunity for to go to the table, get a compromise solution, and resolve your matter, hopefully in a way that's beneficial to not only you but the agency, which is really the definition of a compromise. So, all right, next. All right, we've got some questions. I looked over these briefly. I think that some of these are fact-specific, case-specific. Certainly, I'm not going to really dive into a lot of it, but I'll kind of we'll kind of take a stab at some of these. And I think some of them are sort of interesting. They're a little bit different from garden variety questions. So, yeah, we can take a look. So the first one, contacting the EEOC to start the process considered initiating contact with the counselor. In my mind, no. There is exceptions to the rules, of course, right? Oftentimes we're dealing with non-lawyers, they're complainants, they're employees. So technically, there might be arguments to save your case if that in fact happened. Or there may be a situation in which an EEOC judge remands to the agency for processing or allows a complainant an opportunity to save that claim by going back and filing with a designated timeline. But more often than not, that employee's out of luck if they file with the EEOC. That's not proper contact under regulation. Certainly, if you're a lawyer, you're definitely out of luck. That's not gonna fly. So, long story short, there, without jumping into case law, no. What is the EEO counselor's role in helping to state a claim correctly? None. The EEO counselor has no role to help you do anything. They're neutral in this process. So, they are trained. They are trained on, what's called EEO MD 110, which is basically the guidebook as far as how EEO professionals are to process these claims. You know, and it is audited by, you know, various entities on how these things are being conducted at the agency level. So, you know, they have some responsibility to identify the bases, the claims, but they have they have no obligation to frame a claim, quote unquote, correctly, or delve into, you know, what, like I said, on a narrative that's 3 to 5 pages to make sure that they captured all of your issues correctly. There is no such responsibility. So, none, in my view. I mean, there are, again, a neutral. I mean, I have seen counselors that, you know, are better than others, and you have seen some that seem to be, you know, quite honestly, predisposed to helping the agency frame claims, you know, less than favorably for complainants. You know, no matter what anyone says, there is a bit of a conflict, right? You're getting your salary from the agency that is the respondent to a claim. I mean, that's a fact. If you are, let's see, where are we at? If you have complaints that fall under a different jurisdiction, will the EEO counselor tell you this? Again, no, the EEO counselor has no obligation to tell you that. I wouldn't say any EEO counselor would tell you this. You know, hey, I went to the EEO counselor, but again, my claim is really centered around whistleblower reprisal, and you should have went to the OSC and filed a prohibited personnel practice under 5 USC 2302B9. They're not going to say that. Why would they? They're not going to, they don't know that. They're not going to say that. It's not their obligation to do that. So, you know, no, they have no obligation to tell you that. They have no obligation. You know, there are notices. They are the agency is obliged to, in certain circumstances, inform you of some administrative rights. You know, if that would be a suspension or a removal. In that letter, there is going to be guidance on how to proceed, general guidance and general timelines. You know, of course, it's incumbent on the employee to follow that. But the EEO counselor generally has no such obligation. How do I protect myself when HR knows about the complaint, but still nothing is being done? Well, to some extent, you have to protect yourself by letting HR know about the EEO complaint, presumably, because that's part of a lot of proving structures as the agency has knowledge, and certainly EEO would, HR would be subject to that. So to some extent, you are helping your case there. Document what about being done. Unfortunately, EEO is basically agree later situation, right? So if things are still happening in the workplace, you should be continue to communicate with the EEO office or your lawyer and amending those claims if in fact they're like or related to the underlying claim, so they're added to your claim. So these are all things that can be done. You know, certainly, you know, HR is good, but if your responsible manager is even better if they know of the complaint, right? Because then you open up for a possible reprisal cause of action that could be amended into your complaint, right? So it's sort of a little bit about that question. What should an employee be doing to shore up their assertions prior to filing an informal complaint? I'll speak to a lawyer, right? I mean, yeah, you know, again, I would just stress the importance of that notice pleading format, sort of the who, what, why, where, and when, right? You know, generally a good claim is only 1 to 2 sentences, at least for the portion of filing one, right? It's a claim. It's not your narrative. I mean, you may have all the evidence in the world to support those claims, but that's not the purpose of an informal complaint. It's to, you know, present a complete rendition of, you know, what those claims are. If one obtains legal service for an EEO complaint, when should you contact the attorney regarding correspondences from the firm, EEO case manager, and investigator handling your case? Yeah, I wasn't really sure on this one, what's going on with the question, but you know, as soon as you obtain legal services, that lawyer will be in touch with any of the EEO managers, whether there's an investigator mentioned as an informal, or I'm sorry, a formal EEO complaint actor, or an EEO case manager. You know, that's sort of a peripheral of a EEO counselor, or potentially, depending on how the agency is structured, in the formal complaint. But anyway, the lawyer will be in touch with those individuals promptly, and again, the communication will then go between the lawyer and the agency. regulation actually says that the complainant should be copied on those communications, but in practice, oftentimes the lawyer is forwarding those communications to the client or the employee complainant. All right, what do we got? Can you trust the EEO investigation process in reference to a formal or informal complaint? Well, this claim right here is entirely based on a formal complaint, which we haven't discussed here today. But people have different views on this. I'm sort of the trust but verify. They are obligated by regulation to provide an impartial investigation, to call testimony from various managers, including, the complainant's witnesses. There's terrible investigators out there. In fact, if they're that terrible, you can potentially press for an issue of sanctions. There's good ones too. So it really ranges across the board. I would say it's really case specific. It's not even agency specific because a lot of this stuff is hired out. So it really just depends on the investigator. What do we got? How can you force an agency to comply with an EEOC settlement agreement, and what happens if they don't comply? It's an interesting question. It can happen relevant to what we're discussing here in the informal, right? Obviously, the goal with the mediation is to settle a case. And if one settles a case, then there's a settlement agreement following any successful settlement. So if they don't comply, there's a process to notice basically the division, notice division. It's in regulation of the breach. And the agency has a cure period to cure that breach. And if the agency doesn't cure the breach, then you can, proceed into litigation basically. Another reason it's really important to have legal counsel, in my opinion, at a mediation. I can't tell you how many settlement agreements that the employee believes was breached. When you go and look at the settlement agreement, it's very vague language. It's not specified. Basically the agency lawyer, the general counsel could, drive a truck through this language. So there's nothing really to hold the agency to the fire. That the judge isn't going to rewrite the settlement agreement. So hugely important. Rubber meets the road. You're signing away your Title VII rights. You are giving the agency a waiver. You're taking whatever the agency is giving you as far as relief, and you're giving them the waiver. So, that would be a scary process for any pro se litigant, just to sign away those rights. So that's something that you're going to want to think about. Can you file an EEOC complaint and initiate an MSPB appeal at the same time, or no? Wow, that is one loaded question. So this is an area that even trips up some pretty experienced lawyers. It's mixed case issues. The answer to your question is no. You can't initiate both at the same time, but they can be confusing because you can have an underlying harassment issue, what's considered non-mixed issues. I've been harassed up until the time I was fired from my workplace, and that can be litigated on EEO grounds all the way through the EEOC. But the final claim in this chronology is the firing, right? I was fired because whatever the agency is proffering as this legitimate business justification, and you're saying no, that's actually EEO related. That issue is a mixed issue. That case is not going before the EEOC. That case is going up to the board. So, if this is facts, I mean, you're going to want to talk to someone with some legal knowledge if you're actually thinking about that. Even if say it's a 15-day suspension, 20-day suspension, something that is within the jurisdiction of the MSPB, that's something that an EEOC is not going to hear, right? An EEOC judge is not going to hear. That's by statutory law, personnel action as defined, in which the board has jurisdiction, the MSPB has jurisdiction. So the EEO is not going to hear that case, but you could file informally at the EEO, and there's strategic reasons to do that, to delay the process, to get an evidentiary record through the ROI at the end of the formal phase, and then file up through the MSPB. But again, that case would not be heard, in both jurisdictions. There really is no two bites at the apple over the same claim. However, within a case, there can be different claims heard in different jurisdictions. So it can be very confusing for an employee. Can the lawyer representing the agency be a manager while on your detail? All right, this is a pretty specific question. I don't know how relevant it is to our general audience here, but I imagine it could, it's potentially, yes. I envision that fact pattern being in a general counsel's office, whether that would be an administrator or another lawyer that has filed an EEO complaint, and the settlement authority is actually the manager. So again, a pretty narrow subset of cases. It could probably, that fact pattern probably could arise elsewhere, but it really is an issue of attorney ethics. I don't think that attorney that's representing the agency would actually want to be the manager of their case. So it probably through a, and you're talking about lawyers here, so they probably defer settlement authority elsewhere, I would imagine. I worked at a general counsel's office prior to this world, and defending these cases, and that's certainly what our office would have done. Are there laws regarding reprisal for participating in EEO? Absolutely. Yeah, you can't reprise against someone for their rights to engage the EEO process, whether that be participating or opposing unlawful EEO activity. Anything that may chill your ability to go to the EEO office would be considered unlawful. What is the burden of proof for an EEO claim? Preponderant evidence, majority evidence. There's a whole structure, but if you want to think about, takeaway, it's weighing my theory here. I believe that I was discriminated because of my fill in the blank race. Okay, you're going to start to develop evidence on those grounds, right? How are the individuals of the opposite race treated in similar circumstances? Are there any other individuals that corroborate your theory, et cetera? And then you're sort of weighing that general case, if you will, with the case of the agency saying, no, it wasn't race. It was because performance issue. It was because of an interpersonality issue. It was because of anything that's not Title VII related. The judge is going to have to weigh those two things, and if you can prove as the party with the burden here by majority evidence, not the heaviest burden in the world, if you can prove, by 51% or whatever you want to say, it's more likely caused by EEO issues than the business justification presented by the agency, then you'll win an EEO case. All right. Is there anything else here? Let's see. I think it was going to be it. Okay, I got a couple chat ones here. Maybe I can do one or two. I have one here. How does the process work during the hiring process? It's the same situation for applicants. The agency can take action based on immutable characteristics such as race, sex, national origin, religious affiliation, disability, age, sex, prior activity, anything like that. When you're applying. So generally, if it is a competitive cert, when you're applying and there's a list of candidates, just like any other non-selection case, if you can show that you were the best qualified candidate, thereby undermining again the agency's case that there was some other business justification involved, and show that the real reason was that the selectee was outside of your classification, then there you go. Then that's how you show those EEO cases and present them. So same situation there, but all right. I think we got through everything. I want to thank everyone again for taking some time here and going through the informal EEO complaint process.